The House will come to order. All members take their seats. All guests clear the aisle, please. The clerk will unlock the machine and take the roll. Members will record their presence by pressing the green button. Is there any member present who has not recorded their vote? Please do so by hitting the green button. I hit my green button. The clerk will lock the machine. We have 58 members present. There is a quorum. All rise, please, for the invocation to be delivered by Representative Ruggiero, who will also lead us in the Pledge of Allegiance. Representative Ruggiero.
Beg you to hear, sorry about that. Dear God, we beg you to hear our prayers to end the rancor and the discord affecting our nation. Give strength and courage to those willing to stand up for justice and compassion. Guide our paths so we return to civility and courtesy as we strive to maintain this noble experiment called democracy. Amen. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Representative. Next order of business is the House Journal. Is there any objection to the approval of the Journal of the previous day? Hearing none, so ordered. Communications. The next order of business is communications. Clerk, do we have any communications?
Yes, we do.
If so, please read.
Representative Jacqueline Baginski is unable to attend session today, Thursday, January 28, 2021. Representative Julie Casimiro is unable to attend session today, Thursday, January 28, 2021. Representative Deborah Falella is unable to attend session today, Thursday, January 28, 2021. Representative Ranglin Vassell is unable to attend session today, Thursday, January 28, 2021. Correspondence from Representative Alex Mazalkowski. I regret to inform the House that I am unable to attend session today, Thursday, January 28, 2021, due to quarantining.
Thank you. Received and placed on file. Thank you, Clerk. The next order of business is new business. Is there any new business? Chairman McNamara. Chairwoman Serpa. Representative Carson. Representative Caldwell. Representative Vella-Wilkinson. Representative Perez. Representative Chairwoman Williams, Representative McEntee, Chairman Nazanaro, Representative Edwards, Representative Fenton Fung, McGaw, I'm sorry, Michelle, sorry. You both have the same color dress on, I'm sorry. Representative Place. Any other new business? Am I missing anybody? We can come back to new business. I don't see any new business. Thank you. There's also a box in front. If I've called your name, you can drop off your box, your bills in the box. And obviously, there's a box back at the Speaker's office. Thank you. The next order of business is the calendar. Clerk, please read today's item on the calendar.
Item number 1, House 5002, Sub A.
Chairman Corvesi.
Thank you, Mr. Speaker. Mr. Speaker and members of the House, as the chairman of the House Committee on Rules, I would first like to take this opportunity to talk to you, the members of the House, about the committee's process in arriving at the rules that you have before you today. For the first time in recent memory, the Rules Committee held 3 meetings on the rules. At the first hearing, the committee took testimony on the proposed rules resolution submitted by myself as the chairman, along with rules changes proposed by our colleagues. At the second hearing, the committee heard additional proposed rules from our members and had a lively discussion concerning these and other potential revisions. The committee then brought together and considered the various ideas presented to and discussed by the committee, and at the third meeting recommended passage of a single revised Sub-A rules resolution for your consideration today. The result, Mr. Speaker, are rules we all can be proud of. Today we present the most comprehensive overhaul to the rules that I have seen in all my years as a legislator in this chamber. These rules will assist us in improving our work in this chamber to the benefit of the members and the public we serve. At this time, Mr. Speaker, if it is appropriate, I would like to put the bill in play.
Thank you.
So I'd like to make a motion to put before you House Bill 5002, substitute A2, and I'd make a motion for passage.
Chairman Corvese moves to pass 5002 Sub-A A2, seconded by Leader Blazajewski. I'm going to ask members, if you don't mind, just to hit the purple button on your iPad and I can read them. Thank you. Seconded by Representative Shanley, Norrie, Caldwell, Phillips, Hawkins, Amore, Speakman, Carson, Donovan, Bia, Vella-Wilkinson, Azanaro, Constantino, Serpa, Cortravan, Kennedy, Knight, Fogarty, Shawcross-Smith, Bennett, Slater, Ackerman, McNamara, Hull, Solomon, Steve Lima, Potter, Kazarian, Barrows, Messier, Fenton Fung. Did I miss anybody? Representative Diaz, Representative McLaughlin, Representative Casey, Representative McEntee, Representative O'Brien, Chairman Craven, Representative Cardillo, Representative Ruggiero, Chair William Williams, Chairman Abney. Thank you. Representative Leona Felix. Representative Charlene Lima. Thank you. Deputy Speaker Charlene Lima, I'm sorry. Representative Edwards. I said Representative Diaz. I believe I have all the seconds. Thank you. The bill's been moved and seconded.
Thank you, Mr. Speaker. At this time, I would like to delineate those differences that the rules before you have as opposed to the rules we were operating under during the last session. First and foremost, the words "in Providence plantations" are struck from the introductory clause of the bill. Second, this updates various legislative dates and deadlines, as is typical for every revision of the House rules. Third, this adds 2 new standing committees: a committee on innovation, internet, and technology, which would address issues relating to cybersecurity, data and internet privacy, and emerging technology, including technological innovation in state government, and a committee on state government and elections, which would consider legislation relating to state affairs, governmental departments and divisions, administrative procedures, open meetings, election law, and constitutional amendments. Fourth, it would change the focus of certain existing committees. It splits the former Committee on Health, Education, and Welfare into 2 distinct committees: a Committee on Education and a Committee on Health and Human Services. This change will allow each of these committees to be better positioned to hear legislation focusing on these distinct and important issues confronting our state. Fifth, the former Committee on Municipal Government will now be known as the Committee on Municipal Government and Housing. This change reflects the importance that the House places upon the issue of housing currently facing our communities. Sixth, a new rule would allow members to keep up to 3 bills alive for the second year of a legislative term. This rule would allow a member to avoid the process of reintroduction of the member's priority legislation over the course of the member's 2-year term. 7, it clarifies the procedure for running session in the absence of the Speaker. It allows the Speaker to choose between the Speaker pro tem and the Deputy Speaker to preside in his absence. 8, it allows the Speaker to provide a secure procedure for members to utilize electronic signatures in order to facilitate the legislative process. 9, it provides that the Speaker may allow members to electronically indicate their desire to second any motion, request, or other item. 10, it allows for the names of up to 10 co-sponsors to be published on any bill or resolution, current practice listing only up to 5 co-sponsors. 11, it guarantees each member will be appointed by the Speaker to at least 2 committees. 12, grants to committee chairs the discretion to put representatives of state departments, agencies, and quasi-public agencies under oath while testifying before House committees. Number 13, technical change. It changes the committee which would handle violations of voting procedures from the Committee on Rules to the Committee on Conduct. 14, temporary emergency procedures. In response to the difficult legislative conditions caused by the pandemic, a new rule provides the Speaker with discretion to trigger certain temporary legislative procedures during a public health or other emergency. The temporary procedures would include authorization to conduct remote meetings of House committees. This temporary rule would allow members to participate and vote via video conferencing or telephone as long as the member's identity can be verified. Witnesses would also be able to participate in a similar manner. Under this new rule, committees would vote by roll call. Also, authorization for members to vote on the House floor by proxy. Once a quorum has been met by the physical presence of 38 of the members, the Speaker could temporarily allow members who cannot attend the session to have their majority or minority leaders vote on certain matters on their behalf. The member would indicate his or her preference on calendar items by emailing the House Clerk and the majority or minority leader prior to the commencement of a daily session. The Sub-A amended the new proxy procedure by removing the ability for the majority minority leaders to vote on the member's behalf on floor amendments and other procedural votes. The proxy procedure will simply allow a member to vote in favor or against any item on the daily or consent calendar. In addition, it also allows the majority minority leader, if he or she is unable to attend session, to designate another member to execute proxy votes in accordance with the rule. It allows the Speaker to require during public health emergencies that members comply with public safety measures recommended by the Department of Health while in attendance at any session or committee of the House. Also, utilization of these temporary procedures would continue until the Speaker rescinds them at the conclusion of the public emergency. The allowance of these temporary procedures are intended to allow the House certain flexibility to conduct the people's business while confronting the new realities of social distancing, quarantining, and isolation. 15, finally, the Sub-A provides a more detailed procedure for the discipline of a member, which affords due process protections to the member through the Committee on Conduct. At this time, Mr. Chairman, and if it is allowable, I would like to offer an amendment, if this is an appropriate time.
It is appropriate.
Mr. Speaker, the LC is 613/21, and what this bill does, it solves a problem that was brought up during testimony whereby if the speaker is the target of an accusation of misconduct, that on page 27, line 27, after the language of House, we insert the language, a semicolon, provided, however, if the speaker is the subject of a resolution to expel, the resolution shall be sponsored by the Speaker Pro Tem. I'd like to put that forward in motion. I'd like to have a motion to vote in passage of this amendment.
Chairman Corvese moves Amendment LC 00613/21, seconded by Leader Blazajewski. Representative Shanley, Chairman McNamara, Deputy Whip Ackerman, Representative Phillips, Representative McLaughlin, Whip Kazarian, Representative Tanzi, Representative Fogarty, Representative Casey, Representative Knight, Representative Diaz, Representative O'Brien, Representative Cortravan, Representative McEntee, Representative Vella-Wilkinson, Chairwoman Williams, Chairman Azanaro, Representative Hull, Chairman Abney, Representative Slater, Representative Edwards, Representative Bennett, Representative Constantino, Representative Ruggiero, Representative Norrie, Representative Morales, Representative Cardillo, Representative McGraw, Representative Barrows, Representative Steve Lima, Representative Lombardi, Representative Amore, Representative Speakman, Representative Giraldo, Representative Alzate, Representative Hawkins. I think I said Representative Barrows. I think that covers it. Is there anybody else for seconds for Chairman Corvese's amendment? Representative Bia. I thought I said that, but we'll say it again. Thank you. Any other lights on the amendment? Will the clerk unlock the machine? Oh, I'm sorry? Representative Filippi, my apologies.
No apology necessary. Thank you, Speaker. Would the chairman yield briefly, please?
Certainly.
Mr. Chairman, is there anything to prevent the Speaker from removing the Speaker Pro-Tempore and appointing somebody else?
I would say that there probably isn't, but I think the optics of that would be very unhealthy for a speaker to do that.
Thank you very much. And under this amendment and the way the bill is amended, is there any way to censure or reprimand a speaker?
I believe that with the Speaker Pro Tem, it would go through the same process as any other complaint.
Okay, thank you. I'm going to offer some comments. Thank you. Mr. Speaker, I'll start on my last point. The amendment only provides that the Speaker Pro-Tempore, sorry, I always mispronounce that, only has the authority to expel, to start an expulsion proceeding. There's no way to censure or reprimand a speaker. Essentially, this amendment only really goes halfway. I wouldn't even say it goes halfway, but it takes a step in the right direction, but the speaker is now essentially insulated from as a member of the House, not just as a speaker, but as a member of the House is insulated from censure or reprimand while the remainder of the members, the 74 members, are subject to censure or reprimand. Because I think we can acknowledge a speaker would never institute a process to censure or reprimand themselves. So I think the amendment is in error by excluding those two punishment provisions that are in Article 6, Section 7 of our Constitution. Next, as to delegating this power to the Speaker Pro-Tempore, I think it's very problematic. At our committee meeting, we raised the example of what happens in the first year of a speaker's term if they somehow get pinched. FBI raids an office, it's happened before, and they refuse to step down. Under what we're passing with Rule 48, there is no way, absent this amendment, this amendment makes a difference, but under the prior iteration before this amendment, there was no way for the speaker to be forced to step down. So what happens is now we pass this amendment saying, but the pro-tempore now has the authority, because I think the drafters saw the error in not having that natural check and balance on the speaker, that they could essentially be intransient and this body would be stuck without the ability to proceed without a speaker. So under our rules, the pro-tempore is appointed by the speaker's sole discretion, can be removed by the speaker, and a new one can be appointed. So I don't think this is a healthy check and balance, Mr. Speaker, in that the office of Speaker has the unilateral authority to appoint and remove the person who's supposed to be the check and balance on the Speaker. Maybe the Speaker gets wind that their loyal soldier who's the pro-tempore might be slipping, and they would remove and appoint somebody else.
With all due respect to the leader, I think that, as I said earlier, the optics would be such that there's no way that a speaker could do that. If he were to try to do that, it would certainly be almost an admission of guilt.
It's my time. It's my time. Hold on. I'm reclaiming my time. I'm reclaiming my time.
Hold on. Let Leader Filippi finish first.
I'm sorry.
No, sorry. I thought he asked you a question, but
I thought he did too, and I thought he paused
okay.
for a breath.
No. Leader Filippi, please continue.
I asked my questions. They were answered. I'm giving a statement at this point under my 5 minutes.
Please proceed.
So the issue that I have with it is that, yes, the optics would be bad. So wouldn't the optics of an intransient speaker who the entire body wants to step down, not stepping down would be bad. But the risk we face is that if a speaker is in a pinch, all told, the benefits a speaker gets from the position of speakership equals about $60,000 a year. Now, if they are facing some type of criminal indictment, some criminal trial, that could be a lot of money to somebody. And so at that point, that speaker wouldn't care about optics. We know that there have been elected politicians in this state who have bargained away their position with the Attorney General's office. I will step down but as a condition of accepting a plea agreement. Now, I don't think that would ever happen with leadership that we have now, but we are codifying rules that will be with us for a long time. I know we're going to have another chance in 2 years to look at them, but I think we can see, if you track the history of our rules over the
30
years,
seconds.
they don't change much. So this amendment doesn't do the job. I think there are inherent flaws. And right now, this body, before we pass the rules, all of us have the inherent constitutional authority to reprimand, censure, expel through the proper process. This bill takes that away from every member, puts it solely in the Speaker's hands, subject to the pro-tempore check and balance, which really isn't a check and balance. So I do not agree with this amendment. I understand what you're trying to do, but it does not go far enough. It's fraught with problems. Thank you, Speaker.
Thank you. Representative Price, is your light lit? No, okay. It's okay. Representative Knight, you don't have your iPad with you, Chairman Coase. Did you want to respond?
The only thing I wanted to say with regard to the choice of the Speaker Pro Tem is the fact that this is not something you could leave to an outside entity. It would have to be someone within the framework of the House who's elected the Speaker. So the process has to stay within the House.
Thank you. Representative Knight, is your light lit? Thank you.
Good afternoon, everyone. I rise in support of the amendment, and I just want to point out for the body, Leader Filippi has outlined a potential issue with a rogue speaker, and that certainly could happen, but there are two mechanisms within the rules as they exist now and will exist should we vote them in place that would allow the membership to control a rogue speaker. One is the discharge petition, which can be used to force a vote onto the floor, and the other one is the suspension of the rules by 2/3. If we really got into that boat, you could, and you had a speaker who basically locked himself or herself into their third floor office and refused to do anything, we could discharge a bill out onto the floor to suspend the rules and then get together and frankly elect a new speaker. So there are mechanisms in the rules to account for the apocalyptic scenario that the leader has pointed out.
Thank you. Representative Newberry.
Thank you, Mr. Speaker. Very briefly, I actually wasn't going to get up to say anything on this because I think Leader Filippi said everything I had to say. But I wanted to respond to Representative Knight. If you look at our rules, there is nothing in the rules that can force the election of a new speaker. There's nothing there. The speaker is a constitutional office, so once they're elected, as far as I can tell, they're there until they decide to step down. Now, practical politics is a different story. A speaker that loses the confidence of the body, obviously, and can't put together a budget vote or even get a majority of people to vote for anything is going to step down as speaker, any legitimate political reason. That's going to happen. But a speaker who's facing, and this is not a hypothetical, I don't want to single out names, but we all know who we're referring to here, because I was here and many of us were here when it happened. We had a speaker go to federal prison not too long ago. And one of the reasons, as I understand it, was they were in financial trouble. They were living beyond their means, and they were taking bribes. So the $60,000 salary and benefits may have meant a lot to that person. So the fact that we can suspend the rules, et cetera, I don't think it's that clear, particularly on the issue of expulsion. And the whole point here is I think Leader Filippi has some amendments. I'm glad, I appreciate that the leadership listened to our concerns in committee when we brought this up. I appreciate what you're trying to do. I just think there's better ways to do it. We have a couple amendments on that score, and I think we should vote on this, and I think we should vote on ours and listen to which ones are better, and it comes down the way it is. But we're all trying to do the right thing here. It's not a hypothetical situation. It's happened before.
Thank you. Are there any other lights? I see no other lights. Clerk, will you please unlock the machine? On the amendment, all those in favor of the amendment, please vote green. All those opposed, please vote red. Not voting, I have Representative O'Brien. It hasn't registered. Representative Diaz, Representative Kazar, Representative Fogarty, Representative Hawkins, Representative Messier, and Representative Nardone not voting. Clerk, please lock the machine. 58 in the affirmative, 9 in the negative. The act is amended. Thank you. Back on the bill as amended. Representative Filippi.
Mr. Speaker, pursuant to Rule 28, I believe this is divisible. I'd like to divide out Rule 48 from the remainder of the resolution, please.
Just a moment, please. One minute. Let me get my... I checked with the parliamentarian. It is divisible. So we have some more lights. Do you want to move to divide the rule, section 28, rule 28, 48 out?
So I believe that's a ruling of the chair. I don't know that it's a motion. If
Okay.
it's divisible, I think you order it. And
It is divisible, and we will vote them separate.
thank you very much, Speaker. And then I have an amendment.
Okay. I have some more lights, and then I'll let you come back to your amendment. Representative Morgan. Please.
I see that we're changing it to make state officials have an oath before they testify.
I believe it's at the discretion of the chair.
Okay, I am just wondering why we didn't include everyone who testifies before a committee. Why we only require that of state officials.
Lou? Representative Morgan, that was actually brought up, and I brought that up. I did not think it was appropriate to put members of the public on either side of an issue under an oath, for the simple fact that those type of situations could be used by unscrupulous individuals on both sides of an issue to try to obfuscate the issue with legal problems, lawsuits, threats of perjury. No, I don't think it would be appropriate to put a member of the public, no matter who they are, under an oath. They're coming to testify. I think we shouldn't hold them to the same standard we would hold an appointed official, a head of a department, quasi-public, etc.
Can I just follow up with the
Certainly.
speaker? What about lobbyists?
Again, I think that I don't think that we should be. I think the only ones who should rise to that occasion of being put under oath would be, again, members of government.
Okay, thank you very much.
Thank you, Representative. Representative Price. Certainly, so ordered. Thank you. Representative Filippi, do you have your light lit second time?
Yes, I do. Thank you, Mr. Speaker. I move amendment LC 000613/83, please.
Just one moment, please.
Thank you.
Yep, thank you. Yeah, sorry. Representative Filippi moves amendment LC 00613/83. Is there a second? Seconded by Representative Newberry. I just want to be clear because we're voting, is this an amendment on the whole bill or the Rule 48?
Rule 48.
48, thank you. Just so everyone knows. Proceed.
Thank you, Speaker, and thank you to the body. So I've really racked my brain here on Rule 48, and I think it's wrong on many levels. I think it's wrong from a process level. I think it's wrong from a moral level. And I think it's wrong from a legal, constitutional level. Since 1843, when our state constitution was adopted, this inherent power to have internal discipline has been reserved and held by the membership of this body. But it didn't just come into being in 1843. The common law of parliamentary procedure back to the Parliament in England, it's always been an inherent right of the membership to have internal discipline. So when I look at our state constitution and the responsibilities that we have many responsibilities, but very few functions. The few functions we have manage all of our responsibilities. Our main function, our lawmaking function, is in Article 6, Sections 1 and 2. In Article 6, Section 7, it has our other core functions. Those are the ability to establish rules, the ability to punish contempts, punish members, and expel members. And when you read the actual language of Article 6, Section 7 of our state constitution, it says, each house may determine its rules of proceeding, punish contempts, punish its members for disorderly conduct. It's an inherent power of the House, the membership of the House. And I don't want you to just take my word for it. I'd like you to take the word of the Rhode Island Supreme Court. In Article 10 of our state constitution, it says that the Supreme Court shall issue an advisory opinion when requested by either House of the General Assembly. That's the same language in Article 6, Section 7, which says that each house may punish contempts its members or expel. Same language. What does house mean? Our Supreme Court was faced with that question back in 1937 when a speaker by the name of Speaker Kiernan used procedures to have bills that were on the floor sent back to committee against the will of the majority of the body. The majority of the body then sought an advisory opinion, that language I just read, that each house may request an advisory opinion. And it sought an advisory opinion from the Supreme Court. And the Supreme Court opined on what each house means in our state constitution. And I think it's very clear from our Supreme Court's opinion that when our Constitution says house, that it means the membership of the house. It's a non-delegable power that is inherent in each and every one of us. We cannot delegate it to the Speaker, the same way we cannot delegate our ability to file legislation. Imagine if there were a rule that said only the Speaker can introduce a bill. That undoubtedly would violate our state constitution. And I'll read some of the language where the Supreme Court interpreted what house means when it's used in our Constitution, just like house is used for reprimand and expulsion. We are not unmindful of the generally accepted principle of the law of legislative assemblies that house means a majority of the House. That principle is also the constitutional law of this state. Generally, no business of any kind can legally be performed by any number less than a majority, except to adjourn or compel the attendance of absent members. In other words, majority rule is firmly embedded in our fundamental law and governs the House of Representatives. Going on. So when it speaks to the power of the House to request an advisory opinion from the Supreme Court, it says, the Constitution likewise guarantees a right to the House of Representatives which cannot be denied by anyone without a serious breach of the Constitution. According to well-established principles, the House of Representatives usually transacts its business by a majority vote of a quorum of its members in a meeting assembled. Therefore, a majority of all the elected members of the House are entitled to function in this regard, are entitled under the Constitution, all of us to request an advisory opinion, and all of us to discipline our members.
30 seconds.
I'll read one more line, but I'm going to have to come back because I have a lot more. Because the petitioners allege, although constituting a majority, have not rephrase. We feel the presiding officer, the Speaker at the time, who denied the ability of the majority to seek an advisory opinion, has misconceived his duty towards the majority and will not, when informed, persist in denying them any of their constitutional rights. It's a constitutional right of every member to have this function of reprimand and expulsion. We cannot delegate it. It's inherent in our position as representatives. Just like Speaker Kiernan couldn't take the ability of each of us individually to seek an advisory opinion if we got a majority together, we cannot delegate our authority to reprimand and expel each other to the Speaker. Thank you, Mr. Speaker. I'll come back.
Whip Kazarian, please.
Thank you, Mr. Speaker. I rise in strong opposition to this Republican amendment. I do want to thank Representative Vella-Wilkinson for sponsoring this change to the rules, and I also want to thank Chairman Corvese for adding this section to the rules. I think it's very important that we recognize this change is not about making the speaker more powerful. It's not about taking power away from the members. It's about making the speaker accountable. It's about creating a process to protect all of us, both from being the victim of a political weaponization and also from issues that might happen between member to member. In that first scenario, in political weaponization, with this Republican amendment, anybody could politically shame any other member with complete falsehoods by filing a complaint against them. That wouldn't matter that the Committee on Conduct found nothing. The accused would already have a mark on their record. Imagine, it's an election year. Someone in this chamber introduces a resolution against you just to mark up your record and to help your opponent. Imagine. As the rules are written, they stop this process from becoming used for political weaponization, and it creates a process to make sure that no one would have that happen to them during an election year. In the second scenario, in a member-to-member problem, if there is an issue between members, there has to be a process that must be followed.
Your point of order, please.
The member before, the amendment before the body states that a petition can only be filed when signed by a majority of the membership. I guess I went on too long of a rant and I didn't explain the amendment enough, and I'm sorry for that.
So why don't you let Whip Kazarian finish, and I'll come back to you and you can clarify.
Okay, but the basis of the argument is that any member can file a resolution. That's not what the amendment does. Our amendment says that you have to get a majority of the membership of the House in order to file a resolution for censure or expulsion or reprimand.
I'll get to that in my
State your point of order, please. You use the microphone, please. Thank you.
Leader Philippi cannot use and interrupt Rep. Kazarian's time to somehow correct her argument midstream when she's making a very coherent argument.
It's a germaneness issue. It's not a germane argument.
I rule it out of order. Please proceed, Whip Kazarian. Thank you.
Thank you, Mr. Speaker. In the second scenario, if there's an issue between a member and another member, there has to be a process that must be followed. Without a process, there is no good way for these issues to be handled. I have served in this chamber for 8 years. I have served in this chamber before there was a process. It was not good. Someone needs to be accountable, and who better than the Speaker of the House, every person that serves in this chamber has an opportunity to elect. And how better to make the Speaker accountable than to pass these rules as they are? I mentioned a couple scenarios, and I'm mentioning them because I think they're the most likely to happen. But really, we can't think of every possible scenario and add those to the rules. What we can do is create a framework, and that's exactly what the rules are. They create a framework for us to work with each other in order to pass legislation. The way the rules are written, they match the way this section of the rules is written. It matches the way our colleagues in the Senate operate, and I think it's the best way for us to move forward. Again, I stand in opposition to the Republican amendment, and I'm planning to vote against it, and I urge you all to do the same. Thank you.
Thank you. Representative Place, on the amendment, please.
Thank you, Mr. Speaker. I rise in support of the amendment. I agree with a lot of what Whip Kazarian just said. There does need to be a process, and quite frankly, she kind of set me up a little bit, so I appreciate that. A lot less I have to say. The point we're making with this amendment is that this body already delegates enough things to the Speaker. And again, Mr. Speaker, I do not speak to the man, but to the position.
None of this is taken personally, please.
Thank you, Mr. Speaker.
I know there's a lot of talk, and I take none of it personally. So please, everybody proceed and talk about the office or the person. It doesn't matter. I appreciate you saying that, though. Thank you,
Mr. Speaker. The reason why the Rhode Island Speaker of their House is considered the most powerful person in the state, not because of the Constitution, but because of these rules we're about to pass. That's why. This body is the most powerful element in our Constitution. We delegate that power back to the Speaker through our rules. And with this rule, we are giving the Speaker the ability to really come after people. It's held in one hand. Right now, we all hold this power. And agreed, we have to amend that. But think about it. If you're one of 25 2 years ago, you just didn't get in office. You may have gotten a bad spot in a committee. Maybe you made a really bad decision on the floor one day. How would this rule impact you if we had gone back 2 years prior? We are trying to fix this. We agree there needs to be a process, but the process and the control needs to be in this body. And the way this body controls things is by a majority vote. And that's what we're asking for. We're not asking to strike down the rule. Well, it may be unconstitutional. We're not arguing that point right now. We're arguing that there needs to be a process, and this rule brings that power to you, me, and everybody else in this body, not to the Speaker, to us, where it belongs. Thank you, Mr. Speaker.
Thank you, Representative. Leader Filippi for the second time on the amendment, please.
Thank you, Mr. Speaker. Just to clarify, I'm not limited in the number of times I can rise as the proponent of the
That's
amendment.
correct. I just want to point out,
right,
I have, so everyone knows, I think I have at least 50 amendments, so I don't know how long we'll be here, but we'll be here as long as we have to, so.
I agree, thank you, and I apologize to the body for me probably rising more than twice on this amendment and the bill. So if you read the amendment, we're not proposing that any member can just, shoot and file something at the other one. Our amendment says you've got to get signatures from 38 representatives in order to file a resolution seeking to censure, reprimand, or expel. That's the proper process. What these rules do, this amendment does, what the proposed changes to the rules do before our amendment is they take the power that all of us have now and say that only the Speaker can initiate a petition to expel, censure, or reprimand. Or the Speaker can unilaterally reprimand or censure. I think that second part is just clearly unlawful. The Constitution says the House acts through a majority. There's a quorum requirement. Our Supreme Court has already said House means a majority of the House. So that provision is just clearly unconstitutional, and I would recommend that anyone who got a unilateral censure or reprimand treat it accordingly. Now, if the Speaker says, I am going to file a petition instead for censure, reprimand, or expulsion, it's equally as problematic. One, that he's unilaterally exercising the authority, but suppose we pass the rules as proposed and he has the power to unilaterally exercise the authority. I go back to what my friend Chairman Corvese said about due process. And I would respectfully submit to the body that the core element of due process isn't the few little changes that we've made, and they're good. People have a right to counsel, all that stuff. But the core element of due process is an unbiased tribunal. And I respectfully suggest that any process before any committee that is initiated by the Speaker, at that point, that process is hopelessly conflicted. The Speaker can remove members of that committee, can appoint new members of that committee. Under the proposed rule changes, if the Speaker doesn't like the committee that's there, he can send it to any other standing committee. And I'll quote the United States Supreme Court on the concept of due process, since we're putting that in play. It is axiomatic that a fair trial in a fair tribunal is a basic requirement of due process. We conclude that there is a serious risk of actual bias based on objective and reasonable perceptions when a person with a personal stake in a particular case, in the case that the personal stake is the Speaker sponsoring the resolution to committee, with a personal stake in a case, has had a significant and disproportionate influence in placing the judge, in this case the committee members, on the case. So by the Speaker having this control over the committees, that process is no longer appropriate because the Speaker, and we've seen it before, there's a couple of representatives in this room who dared exercise their independent judgment on the roadworks bill and were yanked off their committees. They were yanked right off when they dared to exercise their independent judgment on a bill. And we all know there is a culture in this room that you can't vote against the speaker. It's happened hundreds of times, my friend, where I've stood up on the floor and probably talked longer than I should. And members would come to me after and they would say, Blake, you were so right. I wish I could vote against the speaker on that. We know it. It's wrong. It's wrong for the speaker to be the only person that can refer something like this. My opinion is the speaker should be nowhere near disciplinary procedures because his involvement or her involvement invariably taints the process. That office, going back to Parliament, should be independent. We've changed it in this country, and I don't think it's bad to give the speaker a political role. But in discipline, expelling members, we cannot allow a speaker to put his or her thumb on the process like that.
30 seconds, please.
We cannot allow it. Let's keep this power where it's been for the past 177 years in the membership. And I would ask any proponents of this rule change to point to me an example where this power has been abused in the past 177 years. Give us an example where it has been abused. It hasn't. I trust the membership of this body. I trust the membership of this body to not abuse it. And if you want to abuse it, you've got to get half. I don't believe half of this body would ever abuse it. You got to get half the people in this room to sign a document in order to start a process under our amendment.
Time. Thank you. Leader Blazajewski.
Thank you, Mr. Speaker, members of the House. Leader Philippi, I know a lot of cases you cited and a lot of constitutional law, but I think you fail in that argument with your fundamental premise, which is that you haven't read the section accurately where this comes from, which is a section 7, Article 6, that says, titled Rules of Houses, Contempt. That's the title of the section, Rules of Houses. And the first 5 words are, each house may determine its rules. I think that might be 6. Those are the first 6 words of that section. And it sets forth other items related to how the House operates. The House operates through its rules. We always have. And what we're doing here and what's getting forgotten in this argument is that there's never been rules for discipline, ever. We're establishing them for the first time. And I just want to thank Chairman Corvesi and the Rules Committee and Rep. Vella-Wilkinson for being brave enough to step up and establish a firm system for discipline for the first time ever. Why has it never been abused? Because it's never existed. We've never had a system for discipline, and now we do. I want to also add that the issues related to expulsion come right from Senate rules that have existed for 3 years. No one's ever argued that those are unconstitutional, and there's been no complaints about this, how the Senate has operated under those rules. So the Senate has done that for 3 years. Again, no indication that it's unconstitutional. And finally, I just want to add that I think Whip Kazarian's argument as to accountability is key. A speaker cannot unilaterally expel anyone. But the speaker has the accountability to start the process and send it to committee. And when it goes to committee, there needs to be an assessment by that committee with due process, again, which has never existed in the rules until today if we pass it as drafted. Never existed. Due process rights, rights for witnesses, rights for documents, rights for subpoena power, rights to have counsel. Never existed before. This team has put these rules in play. So, ladies and gentlemen, I would not get lost in a series of cases from 150 years ago that we don't have in front of us. I would just look at the plain words of what's in front of you and use your own judgment. Is this discipline procedure, which we've never had, is this something where you think that we as a chamber can at least have a system where there's accountability, where there's a process, where there's a committee, where there's an opportunity to be heard, and where there's due process? Thank you, Mr. Speaker.
Thank you, Leader. Representative Place.
Thank you, Mr. Speaker. Again, we're not arguing the fact the system should be in place. That's not an argument. I don't think we're denying the system should be there. Who should have the power? You or the speaker? Again, if you're one of the 25, if you've made some bad judgments on the House floor in the past, ask yourself, who should that power be in? Should it be in your peers, which we're asking that to be, or it should be in the office of the speaker? Because again, everybody knows the man and the man or the person, the woman changes from every 2 years very often. And just think about it. Are you on the right side now? Tomorrow you may not be on the right side. This can be used against you. This body, I trust this body more than I trust the position. Thank you.
Thank you. Representative Filippi.
Thank you, Mr. Speaker. And I'll be brief. The way I understand my brother, Leader Blazejewski's argument is that because this House has the authority to adopt rules, we can therefore use those rules to take away the members' ability to exercise their inherent constitutional function. And I respectfully submit that is wrong. I respectfully submit that we can pass rules that vindicate the functions that we all hold as representatives. We cannot pass rules, and we should not pass rules, which deny our specific constitutional authorities. We should pass rules. Our amendment keeps all the good things Leader Blazejewski talked about, the disciplinary process, going through the conduct committee, going to the floor, due process. All that our amendment does is says the initiation of that procedure should start in the body, not the speaker. So that's what we're trying to accomplish. You can't use the constitutional rulemaking authority of the House to take away all the other constitutional rights of the members. It can only be used to vindicate those rights, to provide proper procedures. It's just like if we pass a rule saying that none of you can introduce legislation, only the speaker can. Only the speaker can introduce legislation, and then it goes to committee, and then we're all expected to vote on it. Absurd. Absurd. The inherent power to regulate each other in this body is at the same level as each of our right to introduce legislation. We can't give it up. Thank you.
Thank you. Chairman Corvesi.
Thank you, Mr. Speaker. When I was in optometry school, one of my professors said that as we continue our studies, we find more and more about less and less. How does that relate to this debate? Most of us in this room are not lawyers or constitutional scholars. We do have more than a passing interest and a passing knowledge of the law. But with regard to what Representative Place said, it struck me. I've been on the in and I've been on the out. And I can tell you that both times, with regard to the institution of the House, the position of Speaker is not just political, it's constitutional. We all vote for the Speaker. We all put our faith and trust into that position. There are occasions that faith and trust has been betrayed, but for the most part, we put our faith and trust in the Speaker. And as a layman, as a non-lawyer, the buck stops with the Speaker. When he leaves this room, when he leaves this chamber, it's he that gets the questions from the press. It's he that gets the heat from the news media and social media. So the process has to begin with the Speaker. It has to be invested there. And that's from a layman's standpoint. So I would urge everyone to defeat this amendment, and we'll proceed.
Thank you. Representative McLaughlin.
Yes, Mr. Speaker, members of the House. You know, I'm listening to both arguments here, and, I'm saying, basically, we already have, the state Supreme Court. It's written in statute. Now, we've all seen, things that have happened, in reference to grievances and, some injustices. I think we can all share with that. But as a body, I'm saying I can relate to a senator, basically, who was accused and the accusation, and I don't know whether he was censored or I think he was censored in the Senate, but that's what we have a Supreme Court for, okay? And so there is recourse, and I would argue any decisions made by the Speaker, we now have a set of rules. I think it's a good set of rules. And it was pointed out earlier, you know, if there was a real grievance, something that was really egregious, we do have the option of the, you know, petition. But I just wanted everybody to know, but there is recourse. What we're trying to do is establish a set of rules. We have recourse within our legislative body. We also have recourse that is in statute, you know, in our Constitution. So no individual would actually be punished if you wanted to actually pursue that. So, you know, therefore I'll have to vote against this amendment. Thank you.
Thank you, Representative McLaughlin. Representative Vella-Wilkinson, please.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, I stand in opposition to this amendment. It's true that we are elected to come here in representation of our particular districts, and I don't know of any one time when I went door to door that I had a constituent say to me, by the way, I think that Representative so-and-so was out of line, and I wish that you had started some kind of proceeding against that individual for either a reprimand or any other form of discipline. It's true that the issue of discipline is a very weighty subject. Well, there's nothing wrong with considering that when we decide who we're going to be voting for Speaker of the House. We're not voting for someone merely to stand at the rostrum and call the events of the day for the session. It's a significant position. It's an individual who is at the helm. The Speaker of the House is our top leadership. And so why not have that individual initiate censure or reprimand or any other form of discipline? Again, we have our constituents who have to live within certain guidelines, who have discipline imposed upon them in their work environments. We're not above the people that we represent. We didn't have the rule before, and perhaps it was an oversight, or perhaps in previous sessions, no one thought that it was important enough to enumerate as a rule. But ladies and gentlemen, in offering this rule, I was not thinking of any one particular representative who may have been considered a miscreant. I wasn't thinking of anything other than what could we do to more mirror the parameters of the people that we represent in their particular work environment. Whether it's being investigated for charges coming from instances of sexual harassment or any other form of discrimination, or something that would be significantly more egregious that would come potentially before the Speaker of the House. The idea of having someone or some people circulating the House to get half of the body's signatures on a petition or a resolution for discipline just doesn't sit well with me. I think that honestly, going back to what Doc was saying with regards to the optics of it, I don't think that that's really what we need to be doing. As members of the House, our focus should be representing the best interests of our constituents, of working towards laws that improves the quality of life for our residents and for our businesses, and not necessarily coming up with solutions to aberrant behavior that's conducted by members that we share the House with. So for those reasons, I ask you to oppose the amendment and vote for the rules in their entirety. Thank you, Mr. Speaker.
Thank you, Representative. Representative Morales.
Thank you. You deserve hazard pay. Thank you, Mr. Speaker. I had a question of clarity for Leader Filippi, if I may.
Certainly. Leader, will you yield?
I will most certainly yield to you, Mr. Morales, please.
Thank you.
Mr. Filippi, if a House member were to experience sexual harassment from a fellow member, which unfortunately has happened before, would they then need to gather signatures from a majority of House members to move forward with a resolution to discipline this individual?
So I believe that the House has a procedure where we have external counsel it would be referred to. But in order to have the House formally discipline, it would be like any other procedure. And I can respectfully suggest that if anyone in this room were sexually harassed, I'd be one of the first ones to sign it, and I think you'd have no problem getting a majority.
Thank you. I just wanted to acknowledge that that is often sensitive information, which is why I thought it was worth mentioning.
Thank you, Representative.
To respond, if it goes to a committee, it would be a public process. That's why the House has external counsel to initially review any type of sexual harassment allegations, but that wouldn't prevent a member from filing a resolution. Now, if the Speaker were to file that resolution, it would become public. You know, unfortunately, no matter what process we use for discipline within the House, it will become public, whether it's the rules proposed or our amendment. Thank you.
Thank you. There are no other, are you all done, Representative?
I just wanted, again, just to acknowledge that that would place an emotional burden, I would imagine, on the individual having to go around to their colleagues and unfortunately have to retell the story of their experience. And I'm not familiar with what the external process is, which is, again, why I only raised a question.
Thank you.
Thank you. There are no other lights on the amendment. Those in favor, please vote green. Those opposed, please vote red. Clerk, unlock the machine. Thank you. Clerk, please lock the machine. There are 11 in the affirmative, 53 in the negative. The amendment is defeated. Back on the bill. Do you want to, I have lights. Representative Norrie, and then Representative Newberry after that. Representative Norrie.
Thank you, Mr. Speaker. Sorry, I couldn't hit my light quick enough. If I could be negative on the amendment. Thank you.
So ordered. Representative Newberry.
Thank you, Mr. Speaker. I have an amendment, if I may.
Certainly. Can you give us the LC number, please?
I'd like to move amendment LC 000613/15.
Just a moment. Representative Newberry moves. Amendment. This is, just to be clear, this is amendment to Rule 48?
No, it's to the rest of the bill.
To the rest of the bill. Okay, thank you. LC 00613/15 is moved by Representative Newberry. Is there a second by Representative Chippendale, Representative Place, Representative Filippi? Are you seconding? Yes, please. Thank you. The amendment has been moved and seconded. Proceed, please, Representative Newberry.
Thank you, Mr. Speaker. So, ladies and gentlemen, obviously, I don't think any of us ever predicted we'd be operating in a pandemic, and I'm very glad that these rules do contain emergency procedures for proxy voting. I'm glad, Mr. Speaker, by the way, that they're confined to emergencies. I would hate to see proxy voting ever become any kind of common practice here for a variety of reasons I don't need to get into. But in a space where people may be in quarantine, I think one of our members announced today is in quarantine, he can't be here. It'd be nice for him to be able to vote on something like the rules by proxy. So I also recognize that coming up with procedures for proxy voting while also trying to match up with constitutional requirements, practical requirements, fairness requirements is not easy. And I think that these rules in general do a pretty good job at that. There is, however, one hole in the rules that my amendment seeks to fill. And I'll explain what that is in a minute, but I will tell you that I did speak to some of the members of leadership about this amendment, this idea over the course of the Rules Committee hearings. And I know one of the concerns and one of the things that was said to me was, well, we've looked at all of this and you can't make it overcomplicated. And I agree. Rules can be made specific as you want to get to a point, but you can't anticipate every eventuality. It's almost like a more detailed form of a constitution. You have general principles, and sometimes you're going to have things arise that are unavoidable, and then you have to deal with them. I get that. But there is one situation that I think these rules do not address, and here's the problem. If you send your proxy in by writing, and I presume most people these days will do it by email, let's say I send a proxy into Leader Filippi. Let's say I'm in quarantine, and there's an important vote coming up, and I send a proxy into Leader Filippi. And I say, I want to vote yes on Bill X. And then that bill is amended on the floor during the debate in a substantive way, not a technical way, not a ministerial way. And by the way, one of the objections I think will be raised is, well, someone has to rule on those. Those of us who have been here before all know that the reality is we all know what a technical or ministerial change is, and I would have confidence in the speaker, either Speaker Shekarchi or any other speaker, to make a fair ruling in that regard. But sometimes bills do get amended in a substantive way on the floor. There's a variety of reasons for that. Very rarely is it a hostile amendment, but sometimes people actually raise issues. Anybody who's been here for more than a couple of years has seen situations where a bill comes to the floor and something is thought of, and there is a substantive change to the bill, oftentimes with the agreement of the sponsor. And that's fine. But the problem is, what if that change changes the mind of the person who put the proxy in? Now, I know the earlier version of the rules had delegation to the majority and minority leader to also vote on amendments, and I think that was wisely taken out. I'm not advocating for that. But I just think simply if a bill is substantively changed on the floor, I think the proxy vote has to be thrown out. I think it's unfair to the member. And the reality is, and this is another comment that was made to me is, well, that's a risk you take when you're voting by proxy. I agree. I agree that it is a risk you take voting by proxy, but if you're stuck in quarantine, you may not have any other choice. And nobody wants to be attacked politically for whatever reasons for missing important votes, quarantine or not, because people aren't necessarily going to remember 18 months later that you were in quarantine when you missed the vote on the budget. So I think this is a fair amendment. I really do. And I want to say this too, as a practical matter, to alleviate any concerns about this being too difficult to administer. Most of the votes we take in this chamber are unanimous. They're not controversial. Even the votes that aren't unanimous usually aren't very controversial. Sometimes people, and I'm often one of them, will vote no on something that 72 other people vote yes on. It happens. Very rarely do we have a vote that's really close, but we do have them. And by the way, this is the key point, our rules already allow you to come back after the fact, and if you can, in the next session, and change your vote if it doesn't affect the outcome, particularly if you had a situation like this arise. This rule will only come into play if there's a very close vote on a bill that's amended on the floor in a way that really causes one member, or maybe in this case, if you have people stuck in quarantine and voting by proxy, several members, to change their votes. It can happen. I remember one year there was an error in the journal, recorded my vote on something. I forget what it was, but I remember noticing it. And it was at the end of we had a long gap before we came back.
30 seconds, please.
I'll be quick. I called Richard Respallo, then the Speaker's legal counsel. I said, there's a mistake here. I need to change my vote when he came back. He was prepared for it. The first thing we did on the floor was switch my vote. Then another representative, for a totally different reason, I think it was Rep. Handy, got up and wanted to change his vote as well, I think the other way, and couldn't do it because it would have changed the outcome. Now imagine if I voted by proxy, and the reason I wanted to change my vote was because the bill had been amended on the floor. The word "not" was taken out, or the word "not" was added, and totally changed the meaning. Is this rare? Will it be rare? Yes, but it's a gap that can be easily filled. I think it's a good idea. I think we should pass it. Thank you.
Thank you. Representative Constantino.
Thank you, Mr. Speaker. On the last amendment, I voted yay. I'd like to change my vote. I hit it by accident.
Thank you. That will not change the outcome, so it's so ordered.
Thank you.
Thank you. Chairman Corvesi.
Thank you, Mr. Speaker. I rise in opposition to my dear friend, Representative Newberry's amendment. We've taken the dramatic and very new step to include virtual voting by proxy, etc. So we're going into a new area here. But with regard to Representative Newberry's amendment, with all due respect to him saying that giving the appearance or giving the impression rather that this is simple, quite frankly, I believe his amendment is basically impractical and unwieldy and quite frankly impossible to implement. And regardless of the faith he says that he would trust the Speaker, and I would trust the Speaker. But who's to determine what is material or substantive, and how can that be determined in a timely manner when we're taking a vote? In addition, the wording of this, the wording of the rules regarding this issue mirrors how the proxy votes are implemented in the state Senate, and there has not been any problem. So, with all due respect to my colleague and friend, Representative Newberry, I would ask that you vote against this amendment. Thank you.
Thank you, Chairman. Representative Newberry.
Thank you, Mr. Speaker. Not to beat a dead horse, I have two comments. Number one, the proxy rules in the Senate are brand new, so the fact there hasn't been a problem, we don't know. I just want to point something out, and this is the real crux of the problem. Let's take a hypothetical. A bill passes on the floor 41 to 33 based on proxy votes, and there's 10 proxy votes that are part of the 41 because 10 people are out in quarantine, 10 people who have similar ideas about the bill. And the bill is changed in a way, and I've seen bills, I have changed my mind on bills that have been amended on the floor. I've come into this chamber, seen a bill on a calendar and thought either that's a good bill or a bad bill, and then there's been an amendment on the floor, and it's changed my vote. It can happen. What if you have 10 people and they make the difference? And it would flip the vote the other way, they would have changed their vote. I think you may have, and this is the issue, Mr. Speaker, I think you may have a constitutional problem with that law. I really do. This would avoid that problem. Do I think this is likely to happen? I don't think it's likely to happen. I think it could happen. And if it does happen and we can prevent it, why don't we? I really think we should adopt this change. I don't think it's unwieldy, Chairman Corvesi, with all due respect, because again, give the Speaker some discretion. I think we all know what a ministerial change is. And again, we're only talking about a handful of times during the course of an entire session, assuming we're even voting by proxy for an entire session. I don't want to overstate this, but why not prevent a simple problem?
Thank you, Representative. Thank you, Representative. Representative Knight.
Thank you, Mr. Speaker. I rise in opposition to the amendment, but not without thinking about it first, because I respect my colleague and his ideas. And again, I'm thinking about some of these amendments that are being offered, and the underlying argument is, in particular this one, this amendment is offered to avoid the body being led down a dark alley with no exit on the other side in the event there's some set of circumstances that are unforeseen today. And I would suggest, Mr. Speaker, that after thinking about it, we don't have the dark alley problem here because there's always the power to recommit. If a bill is changed like that, or could be changed like that, there are procedural rules that would let us pull back from the brink on the vote and allow the members whose opinion has been expressed in the proxy vote but are now in a position of going the other way, we can give them relief. And when you really think about it, this amendment, and this is my second point, replaces one problem with another problem. The proxy voting system is imperfect. As it's written, it's very hard. It's baby steps for this body. It's better than nothing, and I'm glad that we're going to have it in the rules. But the problem that the rep describes, yeah, that could happen. A member could be in a position of voting in a way that they don't want to because of the proxy rule we have. But at the same time, if we declare their proxy null and void, well, then we could be in a position where a member just doesn't have a voice because of the proxy. So this is not perfect, and I think we'll probably work out the kinks. But what we have today is a good start. It's been vetted through committee and talked about, and we shouldn't mess with it. Thank you, Mr. Speaker.
Thank you, Representative. Representative Corvese, did you want to speak? No. Representative Newberry.
Real quickly, actually Representative Knight raises a fair point about not so much recommitting, but I would say this. I still think my amendment's a better solution. I think we should support it. But I would ask you, Mr. Speaker, if going forward, or you or any of your successors, if this ever happens again, if you have a vote on the floor on something that there's been a substantive amendment and the votes are swung by proxy, that you hold it on the desk until such time as you've gotten confirmation from people that they wouldn't change their votes. That's one way to deal with this problem also. But I think we need to be mindful of this. It can happen. It won't likely happen, but it can.
Thank you. Whip Kazarian.
Thank you, Mr. Speaker. I also rise in strong opposition to this amendment, and I do agree with my colleague, Chairman Corvese, on the comments that he made. I also want to point out that this is optional. It's going to be an optional process for us to utilize. During the committee process, it happens throughout the entire session. We hear about the different bills, we formulate our opinions on them, we get an idea of how we're going to vote for them. This is giving us the option to have our vote counted should, for any reason, we're not able to come to session for a particular reason. And especially during this time in COVID, it's good that we have that option. So again, I agree with my colleague, Chairman Corvese, and I do ask the members to vote this down. Thank you.
Thank you. One administrative matter, just for seconds, I believe Representative Price and Quattrochi want to be recorded as voting for the second for Representative Newberry's proposed amendment, correct? Yes, sir. Thank you. There are no other lights on the amendment. Oh, wait a minute. Yes, there are no other lights on the amendment. You gentlemen wanted to speak? Quattrochi, Price, no? I'm sorry, okay. So ordered. Will not change the outcome. Thank you. There are no lights on the proposed amendment. All those in favor, please vote green. All those in the negative, please vote red. Clerk, please unlock the machine. Representative Diaz, O'Brien, McLaughlin, please vote. Thank you. Representative O'Brien is the last light. There are 9 in the affirmative. There are 60 in the negative. The amendment fails. Back on the bill as presented, Representative Place.
Mr. Speaker, I'd like to move Amendment LC 613/87, please.
Just a moment, please. Thank you. Representative Place moves. LC 000613-87. Is there a second? Seconded by, if you could use your buttons, please. Thank you. Representative Quattrochi, Newberry, Nardone, Place, and Chippendale. Proceed.
Thank you, Mr. Speaker. The simple amendment, what this would do is it would codify a process by which if a member has a bill, fairly complicated, technical in nature, that they want to bring in an expert, it would guarantee them, and this would be only one bill per session, this would allow them to request a 2-week notice on when that hearing was going to be held on their legislation, granted by the Speaker, in an attempt to allow their expert witnesses to get to establish their travel time.
Thank you. I have Leader Blazajewski, please. And then I have more lights, but Leader Blazajewski.
Thank you, Mr. Speaker, members of the House. I rise in opposition to this amendment. This actually curtails our current system. Right now, it's within the discretion of chairs to set up times for committee hearings and for length of testimony. And our chairmen are always willing to work with people, especially if they have someone flying from out of state. And we've never put real limitations on that. You know, we do try to run committees efficiently, but if we have experts coming in, this would actually limit that and require experts to have certain credentials or criteria to fall under the categories of this bill, and which is something I think that chills the public process. We want people to feel like they can come up here and testify on any legislation that they feel passionate about, regardless of whether they're an expert or not. So we shouldn't treat anyone differently, and we certainly shouldn't curtail testimony. We've had a system that's worked in this regard, and so I urge a defeat of this amendment. Thank you, Mr. Speaker.
Representative Bia, do you have your light? Thank you.
Mr. Speaker, I'd like to change my vote on the First Amendment from green to red.
So ordered. It will not change the outcome. Thank you. Yes, Representative Place, go right ahead.
Thank you, Mr. Speaker. I don't want to waste the body's time. You know, given the leader's verbal, assurances that this process will continue, I will withdraw the amendment at this time. Thank you.
Thank you very much. Thank you. Chairman Corvese, do you still want to speak? The amendment has been withdrawn.
No, I was going to echo comments made by the majority leader, having been a chairman of 2 committees over the course of my tenure here. I can state from personal experience the chairmen in this chamber always do their best to accommodate any testimony from out of town.
Thank you. There are no lights. The amendment has been withdrawn. The next light, Leader Filippi.
Thank you, Mr. Speaker. I move Amendment LC 000613/16, please.
Just one moment.
Thank you.
Leader Filippi moves LC 000613/16. Is there a second? Seconded by Representative Newberry, Representative Quattrochi, Representative Place. Proceed, Representative Filippi. Leader Filippi, please.
Thank you very much, Speaker Shekarchi. This amendment seeks to correct a ridiculous procedure that many of us suffered through in prior years. Essentially, as we get towards the end of session, even if the rules are or not suspended, if we wanted to have legislative counsel draw up a bill for one of us, we would have to get permission from the Speaker's office, usually the Speaker's counsel. They acted as a funnel which would prevent representatives from drafting legislation. That's not the role of legislative counsel. It's nowhere in our rules that the Speaker has that type of authority or power over the ability of representatives to interact with the drafting body. Our rules provide that you can't submit anything that doesn't have an LC number, and you can only get an LC number through legislative counsel. Now, legislative counsel won't draft a bill unless you get permission from the third floor. Nowhere in the rules does the Speaker's office have that type of power. It's unfair to the members. If the rules permit filing of legislation, we should be able to have our legislative council draft legislation for us to file. It's quite simple. There should not be this artificial funnel, extra rule funnel that has no place in our governing document, preventing us from getting legislation drafted and submitted. So what this amendment provides is that if legislative council, for any reason, refuses or is unable to draft a bill, resolution, or amendment, or otherwise assign a legislative council number, then the representative can draft their own bill or legislation, affix their own legislative number, and as long as it complies with the rules that govern us, it can be submitted in the normal course of business. Thank you, Mr. Speaker.
Thank you, Leader. Chairman Corvese, please.
Thank you, Mr. Speaker. Interesting amendment. I rise in opposition to this amendment. First of all, let me say that this is, with all due respect to my friend, Leader Filippi, this is in effect a step backward for the chamber. We forbade the submission of drafted legislation outside the building many years ago in order to maintain consistency. We had a problem with that. I doubt very much we would want to have those abuses again. In addition, I think it's very important to realize legislative council must have a consistent process by which to maintain control over an orderly system for tracking all pieces of legislation. I understand what Leader Filippi is trying to accomplish here. I actually think it isn't a good idea. It's actually a step backward to when pieces of legislation, believe it or not, were actually drafted outside the building and brought in. I would urge you to defeat this amendment.
Thank you. Leader Filippi.
I understand those concerns, Chairman Corvese, but those concerns are far outweighed by the harm in legislative council refusing to draft legislation for representatives. And if you read this amendment, it would only apply when legislative council is unable or refuses to draft the legislation. So all of us aren't going to be going out, scribbling on pieces of paper, trying to figure out how to draft a bill. It's only going to happen when legislative council refuses. And frankly, with this rule, they'll never refuse because they don't want the garbage you talked about being filed. So this rule will prevent the very problem that you're concerned with and I'm concerned with, because they'll never say no if this rule is on the books, and we'll have properly drafted legislation, because this rule only applies when legislative council refuses, and they won't refuse if we pass this amendment.
Thank you.
Thank you, Speaker.
Leader Blazajewski.
Thank you, Mr. Speaker, members of the House. I rise in opposition to this amendment. I think what Leader Filippi is getting at is the 7D process we have here. You know, we're all entitled to 3 additional bills under Rule 7D, and for those of you that are new, you'll see that after a certain date, you can submit 3 more bills, and after that, it's with the permission of the Speaker. So I believe that's what he's getting at and where he thinks that there's an issue, but in my time, I'm not aware of any particular issues where this has come up, where legislative council has denied ability to draft a bill. And if it is, it's going to be in the situation where you require the permission of the Speaker after a certain period of time when it's getting late in the session, and we don't want new bills going in that could have been drafted earlier, and to avoid late legislation not getting the analysis that it really needs and the public vetting. So for those reasons, Mr. Speaker, I urge defeat of this amendment. Thank you.
Thank you, Leader. Representative Newberry, please.
Thank you, Speaker. Very briefly, I think the issue here goes back to the prior regime. And I agree, I have no problem with the way the rules are structured to allow people to introduce bills up to a certain date, and then the Rule 7D process. And I know after the 7D expires, that you do need permission of the Speaker to introduce bills, unless they're town bills or solemnization. The problem that Leader Filippi is getting at is, in the past, You were not even allowed to get a bill drafted so you could bring it to the speaker to ask whether it could be introduced. That's my understanding. I know that's my understanding speaking to Leader Filippi. I hope that would not happen with or without this amendment. Maybe if there was some general agreement that wouldn't happen. No guarantee it'll be introduced, but at least it can be drafted by alleged counsel. That might obviate a need for a vote. That's I don't know. That's up to Leader Filippi, but.
May I be recognized?
Of course, I'm sorry. Leader Filippi, I was waiting for him to give you the microphone.
Thank you, Mr. Speaker. And thank you, Leader Blazejewski. You know what happens when we assume things? It's not the 7D process, which is the issue. It's when I've encountered the issue when the rules have been suspended. And when the rules are suspended, including 7D, every member should be treated equally by legislative counsel. And even when the rules aren't suspended, if 7D is applicable, the proper place to prevent bills that don't comply with 7D is on the clerk's desk. When I rise, I submit a bill and I didn't comply with the rules, it doesn't have to be accepted by the clerk. It's not downstairs. Downstairs should be neutral. They should not be under inordinate influence from anybody. There are attorneys. And so that's really the intent of it. I have a feeling the speaker is going to treat us differently. I have a good feeling, but I had to put this on the record because it's something that is improper. It's something that I faced numerous times with this body, and I would like a vote on it, but I don't think we're going to need it. But I'm always worried about the next speaker, whether he or she would reinstitute that process, which is unfair to the members. Thank you.
I'm just asking, are you withdrawing it, or do you still want to vote on it? Because there's no more lights.
I'll withdraw it in a gesture of good faith, Mr. Speaker.
Well, thank you very much.
I appreciate that.
We appreciate that. All your colleagues do. Thank you. The amendment has been withdrawn. There are no other lights. Point of order. I don't know. Let me ask the parliamentarian. That's a good question. It's the amendment. Okay. Okay. Yes, so we will withdraw all the seconds. Thank you. That's a good point of order. Thank you. Yes, you're right, but I blame that on you, Representative, because you didn't tell me.
Mr. Speaker, just a point of order in response to my brother, Rule 29. After a motion is stated or read by the clerk, it shall be deemed to be in possession of the House. But any motion may be withdrawn by the mover at any time before a decision or amendment. I'm the mover. It doesn't require seconds.
No,
So-
we're not asking for seconds.
No.
I think what he's saying is that when you withdraw, the seconds also withdraw.
I understand that. I just don't know if that's required under Rule 29. I don't know that it's required that the seconds also withdraw.
Yeah. Okay, I don't know. Let me ask the parliamentarian, but I was told yes, so just a moment. Does it have to be withdrawn the seconds or no?
I've never, in 15 years, I've never seen it done.
Okay.
So once the bill is withdrawn, everything is withdrawn. All the votes are withdrawn,
Okay. The ruling that I'm getting, gentlemen, so you know, is that once the bill is withdrawn, the seconds are withdrawn. I don't think it needs to be articulated. I think you're both right. How's that? So the bill gets withdrawn unilaterally, and then the seconds also get withdrawn. Thank you. There are no other lights on the bill. We're going to vote. It's been moved as divisible. We're going to vote on the bill without section Rule 48. So the motion will be, I have a light, I'm sorry. Representative Knight. No? I'm sorry, Representative Kislak, I'm sorry.
Hi, I just want to confirm that we're on the rules as a whole, yeah?
No, not as a whole, because we're going to divide Rule 48. And
Okay.
then it will be all the rules, and then we'll have another vote on Rule 48.
Okay, great. I think this is a great time for me to speak with your permission. Thank you very much.
Proceed.
I love a good rules conversation, and I'm really glad that we had one tonight. I'm really grateful that the committee had 3 meetings, hearings on the rules, and I appreciate the opportunity to present more thoughts about how we can continue to move forward as a body. We are making lots of progress, and I've started to think of the rules as an equation. I don't know why, but I wanted to share that with folks tonight, that the rules as they're written down plus our culture as a body equals the way that we do things. And I am hopeful and optimistic that we're moving forward and working together in both of these areas. I think that we do need to take more time to think about the Committee on Conduct, which is why I'm going to vote no on that section. I think we're making a lot of progress with these rules, and I'm proudly going to vote yes on the rules as a whole, except for that rule. And I thank you all and ask you to join me.
Thank you, Representative. Representative McNamara.
Thank you, Mr. Speaker. And I just want to take a second to thank the chairman and the members of the committee, and also thank the 8 members who came before the committee, offered amendments. I believe 6 of them were incorporated. And Mr. Speaker, the historic perspective of this is very, very impactful. I have been here for over 2 decades, 5 speakers. You are the 5th speaker who has amended the rules in 2 decades. This is the most historic and significant amendment of House bills, the House rules, in 20 years. So I thank you for that. I thank you for rules that bring us into the 21st century with electronic signatures, proxy voting, and mechanisms for conduct and expulsion. This is a historic moment, and everyone that's participated today should just take a second and realize we've done something significant. I hope everyone votes in favor. Thank you, Mr. Speaker.
Thank you. Representative Tansey, please.
Thank you, Mr. Speaker. I agree with what everyone has said. This has been a very open process. In my 10 years, this has been the most open process it's been. And I appreciate every person who came to testify as well, and the input was really dynamic. I agree with Representative Kislak. When the divisible question comes up, I will be voting against that section as well. And for me, it's very simple. Access to justice should no more be through a single person than it should be through 38 people. I think there has to be a better way. I'm not saying I have that answer, but I am saying that 49 other states have ways that they conduct themselves. And I think that there are critical things that we're voting on tonight that should absolutely be voted on tonight. We need them to move on to do the work that we have all been eager to begin. But I think that this one has the ability, if we keep the gatekeeper at one person, this has the ability to haunt us 10, 20 years down the line. The integrity of the people in this room, off the table, not even discussing that. It's what the next speaker is going to do. It's what the 5th speaker after this speaker is going to do. And we will have been the ones who enabled that person to be the sole gatekeeper to justice for the other 74 members in that room. And I simply think that we can do better. I think we should vote the rest of the rules through tonight. Let's get to work. It's long past time. We're chomping at the bit to do things and get work done. But as far as this conduct, I really appreciate the attempt, But there's no reason to rush this part through. Let's get to voting, let's get to business, but let's hold another rules meeting. Let's make it a real record. Let's go for 4 or 5 rules meetings, and let's really set a precedent. I appreciate the time. Thank you.
Thank you. Representative Ruggiero, please.
Thank you, Speaker. And it's Ruggiero. Donnie is Ruggiero. We have our eyes in different places.
I don't know if you were here the other day when I said it took me several years to learn Blazajewski and Mazakowski, but I will get there.
No worries. Ladies and gentlemen of the House, good afternoon. I stand before you because I'm very excited about the conversation and the debate. My gosh, I have missed you guys. Thank you for this. As you recall, 2 years ago, I was one of the 25 of us in the Reform Caucus, and we put forth a number of House rules to be more transparent, to be more efficient, and those rules fell on deaf ears. Today, we're actually going to be voting on some of the rules that we put together, and for that, I do thank Leader Blazajewski and Speaker Shekarchi. It's really important that we keep certain things in play, like 3 bills, at least, because we're here for 2 years. We also are in the midst of a pandemic, lest we forget. And some of these rules that we're doing are innovative, where we can vote by proxy. We can also do electronic signatures. We can have committee hearings by remote. Some of these things should have been done a year ago, but they've been done. Is this bill perfect? Absolutely not. And you know something? You will never have a perfect bill in the House. It doesn't exist. But the beauty of the perfection is in the cracks, because that's where the light shines. And that's where we make changes. We put in amendments. I'm not worried about the speaker who's 4th, 5th, or 6th. We will change this next year. We could change this in 5 months if we need to. So for that, I want to thank Rep. Corvese, who's chaired this committee, a number of my colleagues who put forth some really good ideas in the collaboration. I would ask my colleagues to vote on these House rules, and let's get back to doing the people's business. Thank you.
Thank you, Representative. Representative Corvese. Chairman Corvese.
Am I the last light, Mr. Speaker?
You are the last light.
Then I'll keep my comments brief. Once again, I'd like to thank the committee that I worked with, the individuals, the reps came before us to testify, who gave their input, most of which we included. I'd especially like to thank you, Mr. Speaker, and Majority Leader Blazajewski for the charge you gave us, the direction you gave us, and the product that's before us. And I would urge every member of this House to vote for that entire product. Thank you.
Thank you, Chairman. Thank you for the kind words. Let's vote on the bill as a whole without a Rule 48. All those in favor, clerk, please unlock the machine. All those in favor, please vote green as the vote as a whole without Rule 48, and those against, red. Thank you. Representative Perez and Hawkins, please vote. Representative Handy, please vote. We have 60 in the affirmative, 7 in the negative. The act shall pass. Now back on Rule 48. The rule has already been moved and seconded. On Rule 48, all those in favor, please vote green. All those against, please vote red. Clerk, please unlock the machine. Thank you. Representative Casey, please vote. Representative Hawkins, please vote. Clerk will please lock the machine. Rule 48 passes on a vote of 48 in favor, 19 in negative. The act passes as a whole. Thank you. Thank you. Representative Knight, do you want to be recognized? Please.
Out of an abundance of caution, I'm wondering if you've passed the rules first, right, without 48, and then 48. I would suggest that perhaps you hold another vote for a unified bill that includes both the body that we voted first and 48 combined into one rule set, so there's no question.
So I'm going to say you're absolutely right, and I appreciate that, and you and Chairman Kovesi. So out of abundance of caution and probably to follow the proper protocol, I'd like to not revote, but I have another vote on both the rule as a whole, including Rule 48, similar to what we do at the budget time. Clerk, would you please unlock the machine? All those in favor as the rule as a whole, please vote green. And if in negative, please vote red. Representative Vella-Wilkinson, please vote. Thank you. Clerk, please lock the machine. 57 in the affirmative, 8 in the negative. The rules as a whole shall pass. Thank you. Thank you. Thank you all for a very spirited debate and for all points of view, because I really believe that we are a better house when we have debates on the merits. Next order of business is announcements and introductions. Are there any announcements or introductions? Representative Knight.
Thank you, Mr. Speaker. I'm sorry, I feel like I'm talking a lot today, and I apologize. But I just want to recognize and make an announcement. Today is my daughter Talia's 18th birthday. And
congratulations
I'm
to
very
Talia.
proud of her. And I am very proud of myself. I got her this far with all her fingers and toes.
And let's hope you do something nice for her tonight. Thank you. Deputy Speaker Lima. No, you turn it on, please.
Oh.
There you go.
I have a resolution for immediate consideration with permission from the majority leader and minority leader on the passing of former Channel 10 reporter Bill Rapley, who was a wonderful man, won numerous awards, including the Associated Press Award. And I just want to say, for all the times I've been interviewed, Bill Rapley was the best. He was truly a man that got to the issue, but he was fair. And Bill Rapley came to my house. The most memorable time was with his dog, Olivia, to interview me on my doggy restaurant bill. And he said, I have my dog in the car. I said, oh, bring her in. And Olivia comes in and runs right over to Kiko's toy box, and I'm dying. I'm saying, oh no, Kiko doesn't share like her mommy. And I said, please, Kiko, don't eat the reporter's dog. But they got along really, really well, and Kiko jumped all over Bill Rapley, kissing him and loving him, because animals know good people. Bill Rapley was a special man. He was a good man, and he's going to be deeply missed. Thank you.
Thank you. Please send it up, Representative. He was a great reporter and a good human being. Thank you. Representative Azanaro.
Thank you, Speaker. Announcement, please.
Please proceed.
56 years ago, I was blessed with a baby girl. So it is my eldest firstborn's birthday today, and she is down in Florida celebrating her 56th birthday. So happy birthday, Tammy.
Congratulations. Thank you very much. Representative Giraldo.
Thank you, Mr. Speaker. I was having some issues with my iPad earlier on. I'm not sure if I was marked present, and if I wasn't, can I please be marked present?
So ordered. Thank you. Representative Diaz.
Thank you, Mr. Speaker. I request to back to new business. And also, Mr. Speaker, I'm requesting to adjourn in the memory of B.M. Garcia. I mentioned before, and I see resolution that I would like to be read at the end of the session. Thank you.
Please send it up. Thank you very much. We will do that. Representative Potter.
Thank you, Mr. Speaker. An announcement, please.
Proceed.
I'd like to just ask that the House adjourn today in memory of John Gabriel. He was my great uncle who passed away last week at the age of 87. He was the last surviving sibling out of 7 of my grandfather, Fidanzo. He leaves behind his wife, my Aunt Eileen, 2 daughters, Joanne and Donna, a granddaughter, Amanda, and 2 great-granddaughters, Hallie and Hannah, and many other nieces and nephews. He was a member of the United States Marine Corps and served honorably in the Korean War. Later went on to work for the Providence School Department for many years, coached the North Providence Jets, and as of most recently, he was an employee at the State House in our very chamber, where he tended the door and cleared the aisle upon request. He was a very admirable man, a very kind man, and I know that he would be very honored to be formally recognized by our chamber. So thank you, Mr. Speaker.
Thank you. Our condolences to you, Representative, and your whole family. Thank you. Chairman McNamara.
Thank you, Mr. Speaker. Request for adjournment, please.
Proceed.
Mr. Speaker and ladies and gentlemen of the House, I would like to respectfully request that we adjourn in the memory of Bernard Long. Bernie was a retired supervisor for the Postal Office, president of the Providence Postal Credit Union, and Mr. Speaker, he was president of one of the most influential organizations in Warwick and Cranston and the state, the Gatsby Day Committee. And as that president, he did a fantastic job. He's greatly loved in our community, and he will be missed by his family and his friends. Thank you, Mr. Speaker.
Thank you. Our condolences. He was a fine gentleman. Representative Handy.
Thank you, Mr. Speaker. If I may be recorded in the affirmative on the last 3 votes, the votes on Rule 48, the balance, and then the whole bill, I had to step outside for a minute.
So ordered. Will not change the outcome of the vote. So ordered. Thank you. Representative Filippi.
Thank you, Mr. Speaker. Negative on the final vote, please. Won't change the outcome.
Absolutely. So ordered. Representative Place.
Mr. Speaker, I have a resolution for immediate consideration with the approval of both the majority and minority leaders, if I may.
Certainly, proceed.
Roger, it just recognizes that this week is School Choice Week nationally.
Absolutely. Thank you. Please send it up. Representative Blazajewski. Leader Blazajewski.
Thank you, Mr. Speaker, members of the chamber. I have a House resolution with the permission of the Minority Leader, Filippi, expressing the deepest condolences on the passing of John Brito. John Brito was an absolute just centerpiece of Fox Point for so many years. For 50 years, he was the athletic director at the Fox Point Boys and Girls Club, supported 5 generations of Fox Point children growing up. My daughter's gone to the Fox Point Boys and Girls Club. My son has, and many people in our community have gone through that Boys and Girls Club on their transition from childhood into adulthood. He had a huge impact on so many. He leaves behind several family members and many in the community that remember all of his work, but I want to specifically mention Anthony Brito, John Brito, the Honorable Robert Brito, Karen Farmer, and Donna Silva. John Brito will be deeply missed by Fox Point and by his neighbors and friends and family, and I ask that this be considered, Mr. Speaker. Thank you.
Thank you. Please send it up. Thank you. I have a resolution presented by Deputy Speaker Lima extending condolences on the passing of Bill Rapley. Moved by Representative Lima, seconded by many others. All those in favor say aye. Any opposed? The ayes have it. I have a resolution recognizing the week of January 24th through January 30th as the National School Choice Week in the state of Rhode Island, presented by Representative 47. Representative Place, and I thought I had bad handwriting. Representative Place and many others. All those in favor, please say aye. Any opposed? Resolution passes. The final resolution I have, actually I have two more. I have a resolution on, presented by Representative Diaz and many others, expressing condolences on the passing of Benavieve Garcia. All those in favor, please say aye. Any opposed? Motion carries. And the last resolution I have is by Leader Blazajewski and many others, expressing deep condolences on the passing of John Brito. All those in favor, please say aye. Any opposed? The resolution passes. Yes, all of those will be read after and left out for signatures. Is there any objection to transmitting all matters on the clerk's desk to Her Excellency the Governor and the Honorable Senate or the Secretary of State forthwith? Hearing none, so ordered. Leader Blazajewski moves that the House adjourn in memory of... Yep. I'm sorry, new business?
No, Mr. Speaker, we have announcements, please.
Okay, 1 second. I jumped the gun. I know everybody wants to get out. Let's go back to new business. Chairwoman Williams has new business. Is last call for new business. Representative Alzate has new business also. Is there any other new business? Thank you. New business, the desk will remain open and new business can be brought up after. For announcements and introductions, Leader Blazajewski.
Thank you, Mr. Speaker. Announcement, please.
Proceed.
Mr. Speaker, ladies and gentlemen of the House, now that the rules have passed, watch for your emails in the coming days because we'll be sending you all of the committee assignments. As you know, the new rules called for the creation of several new committees, so we couldn't finalize the committees until after the passage of the rules. Also, please check on the legislative website for committee postings in the next few days. There will be several committees posted for hearings next week. We will be meeting in session next Tuesday, February 2nd, and Thursday, February 4th at 4 p.m. in the Veterans Auditorium where we are right now. While we will not be in session on Wednesday, February 3rd, Governor Raimondo will be delivering her final State of the State address at 7 p.m. She's also scheduled for a vote that day to be confirmed. It will be carried live on Capitol TV and local TV stations at 7 p.m. Due to COVID restrictions, the usual joint session of the House and Senate will not be held this year. Also, in case you missed it on the way in, you all have new ID badges at a table in the lobby. Please keep checking your email as we finalize the DocuSign process in the coming days. In the meantime, you are submitting bills in the traditional way. Please be sure to add your district number following your signature so we know who signed that line. And then I mentioned previously, and someone pointed out to me that I mentioned that you should go to Ledge Council to have your bills drafted. I didn't mean you always had to physically go to Ledge Council. You can call them, you can email them, you can get in touch, but just stay in touch with Ledge Council. And last but certainly not least, Mr. Speaker, I wish a very happy birthday on Friday to Chairman Azanaro. Happy birthday,
happy
Chairman.
birthday, Sam.
Thank you, Mr. Speaker.
Thank you. Leader Blazachewski moves that the House adjourn in memory of Donald Pincinci, John Gabriel, Bernard Long, Bill Rapley, Belu Garcia, and John Brito. The motion is seconded by Leader Filippi. All those, please stand for a moment of silence. The House is adjourned. And as I said earlier, the desk remains open.
House resolution recognizing the week of January 24th through January 30th, 2021 as National School Choice Week in the state of Rhode Island. Whereas National School Choice Week 2021 will be recognized across the United States of America from January 24th to January 30th. And whereas National School Choice Week provides an unprecedented opportunity every January to shine a positive spotlight on the need for effective education options for all children. And whereas National School Choice Week is independently planned by a diverse and growing coalition of individuals, schools, organizations, and features thousands of unique events and activities across the country. And whereas participants in National School Choice Week believe that parents should be empowered to choose the best educational environments for their children. And whereas the National School Choice Week allows participants to offer insight for Rhode Island families and organizations into the endless possibilities for achieving educational excellence through school choice. And whereas this year, schools and organizations across Rhode Island will partner with families to raise awareness for the variety of school choice options, from traditional public schools to public charter schools, magnet schools, private schools, online learning, and homeschooling. And whereas National School Choice Week is a nonpartisan public awareness effort and welcomes all Rhode Islanders to get involved and learn about the broad educational opportunities for the children of our state and for the future of our state. Now, therefore, be it resolved that this House of Representatives of the state of Rhode Island hereby recognizes the week of January 24th through January 30th, 2021 as National School Choice Week in the state of Rhode Island. And be it further resolved that the Secretary of State be and hereby is authorized and directed to transmit a duly certified copy of this resolution to Mr. Andrew Campanella, President, National School Choice Week. Yep, right now. House resolution expressing deepest condolences on the passing of John Brito. Whereas Johnny Brito, a legendary fixture within the Fox Point community, passed away on January 26, 2021. And whereas Mr. Brito served as the athletic director at the Fox Point Boys and Girls Club until his retirement in 2017 and was a positive influence in the lives of 5 generations of Fox Point residents, especially members of the Cape Verdean community. And whereas Mr. Brito was always available to assist those in need, and his advice and wisdom were highly valued by many, especially newly arrived immigrants from Cape Verde finding their way in a new country. Whether Mr. Brito was teaching kids how to play basketball, refereeing a sport activity, or telling interesting stories with important life lessons contained within them, the one constant was that he was always striving to ensure that the Fox Point neighborhood was a welcoming and safe place in which all residents, including new immigrants, could thrive and realize their full potential. And whereas Mr. Brito received numerous awards and honors throughout his distinguished public service career, including the Outstanding Citizenship Hero Award from Blue Cross and Blue Shield of Rhode Island, induction into the Martin Luther King Jr. Hall of Fame by the City of Providence in 2013, and most recently he was among 6 Fox Point elders honored by the City of Providence. And whereas Mr. Brito leaves behind his 5 children, Anthony Brito, John Brito, the Honorable Robert Brito, East Providence City Council President, Karen Farmer, and Donna Silva. Mr. Brito was the father of the late Denise Brito. He also leaves behind 10 grandchildren, And now, therefore, be it resolved that this House of Representatives in the state of Rhode Island hereby expresses its deepest condolences to the Brito family on the passing of John Brito. And be it further resolved that the Secretary of State be and hereby is authorized and directed to transmit duly certified copies of this resolution to Anthony Brito, John Brito, the Honorable Robert Brito, Karen Farmer, and Donna Silva. House resolution expressing condolences on the passing of Benvenido R. Garcia. Whereas Benvenido Bien Garcia, a lifelong Providence resident and distinguished community activist, passed away on January 19, 2021. He was the son of Rosa Garcia of the Dominican Republic. And whereas Benvenido Garcia was a tireless advocate on behalf of the Dominican community residing in the south side of Providence. He was a social worker and a program manager for the Urban League of Rhode Island, who strived daily to attain good jobs, good schools, and access to quality health care services for his community. And whereas Mr. Garcia was also a founding member of both the Club Juan Pablo Duarte and the Dominican American Association of Rhode Island, he was a kind and caring person who was always available to help someone in need. And whereas Mr. Garcia is survived by his former spouse, Carmen Torres, and his 4 children, Tanya Garcia, Rashida Garcia, Joseph Garcia, and Raisa Garcia Diaz. He also leaves behind his 7 grandchildren and his 3 siblings. And whereas Mr. Garcia's legacy of service to the Dominican American community of Providence and to the unfortunate living amongst us will never be forgotten by the many people who deeply respected and admire Mr. Benvenido. Now, therefore, be it resolved that this House of Representatives of the state of Rhode Island hereby expresses its deepest condolences to the Garcia family on the passing of Benvenido Garcia, and be it further resolved that the Secretary of State be and hereby is authorized and directed to transmit duly certified copies of this resolution to Carmen Torres, Tanya Garcia, Rashida Garcia, Joseph Garcia, and Raisa Garcia Diaz. House resolution extending condolences on the passing of Willard Bill Rapley. Whereas it is with sincere sadness that this House has learned of the passing of Bill Rapley, a renowned veteran political reporter and the beloved father of 5 daughters, Georgia, Annika, Chesley, Karma, and Layla Rapley. And whereas Rapp, as he was commonly known in journalistic and political circles, was a brilliant journalist and a person of acute perspicacity, who thoughtfully and relentlessly pursued the news in an inspiring career that spanned almost 40 years. And whereas Mr. Rapley was born in Houston and raised in Cambridge, Massachusetts, but the Ocean State was always his true home. He was the son of Ann and Fuzz Crumpton and the brother of Tim Rapley and the late Charles Rapley. His nascent career began in the early 1980s, working as a photographer reporter for cable television in New Bedford. He subsequently spent 7 years at WLNE, where he reported on numerous events and established himself as the station's environmental reporter. He also held reporting positions in Boston and New York. And whereas for almost 18 years, Mr. Rapley was a political reporter with WJER Channel 10, during his tenure at the station, he hosted the public affairs program 10 News Conference, moderated debates, reported from the New Hampshire primary and national conventions, and interviewed countless local, state, and federal politicians. Most recently, he worked with Rhode Island's public television station, WSBE, where he worked on longer-form investigative projects and was the co-host of Rhode Island PBS Weekly. And whereas Mr. Rapley's comprehensive reporting of Rhode Island's political issues and events has been well-reasoned and thoughtful, and his reputation was fully appreciating the power and intensity of ethically reporting the news earned him the admiration of both his peers and those he sought to interview. And whereas, in addition, Mr. Rapley earned a plethora of awards and nominations for his coverage within the Rhode Island State House and Washington, D.C., included the Associated Press Awards, a Regional Emmy Award, a National Award from the Association of Capitol Reporters and Editors, and numerous additional accolades. And whereas Bill Rapley was a brilliant journalist, a good friend, an amazing father, and a true gentleman who had left the people of Rhode Island more informed and enlightened by his life's endeavors. His integrity and common sense enriched the lives of all who knew him and set a standard for journalistic excellence that is an inspiration to us all. Now, therefore, be it resolved that this House of Representatives of the State of Rhode Island hereby expresses our deepest sympathies on the passing of Willard Bill Rapley. And be it further resolved that the Secretary of State be and hereby is authorized and directed to transmit a duly certified copy of this resolution to Ann and Fuzz Crompton and family.